The defense lawyer made a settlement offer and a week later he took it back. Can he do that? Is that appropriate? Is that ethical? Can the defense lawyer make an offer and then take it back and say, no, there's no offer on the table anymore? You want to know the answer? Come join me on this walk along the beach as I share with you the answer to that question. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. The answer is, yes, he can. During the course of this particular case, a medical malpractice case, we were getting close to trial. The defense attorney made me a settlement offer, which was a very reasonable offer. It was a good offer. It wasn't a great offer, but it was a good offer. And he told me, listen, I can only give you this offer for a week. This offer is valid only for 1 week. Go ahead and talk to your client, see what your client has to say. If your client does not agree to the settlement offer, there will be no more offers coming and we will withdraw that offer. So basically, what he's saying is it's an all or nothing offer. Either you take it or you don't, and if you don't, we go to trial. Okay, so now I have an obligation as your attorney to pick up the phone and call you and say, okay, Mrs. Jones, I just want to let you know that we now have a settlement offer. The defense has offered this amount of money, but you should know, the defense has put a time limit on this offer. So you have 1 week in which to answer. If you fail to answer within that 1 week, then the defense is going to withdraw their offer, and then we will have no choice but to go to trial and take our chances with a jury. So I go ahead and relay the offer to you. You go ahead and are very upset with the offer. You think your case is worth 10 times as much as what the offer is. And we have an honest discussion about the real value of your injuries, about the value of exactly what your permanent injuries are, or whether or not you have any permanency, whether or not you are able or unable to work. And I go through with you and explain to you the risks of going to trial, the risks of turning down an offer like this, the risks of going to trial, getting a verdict in your favor that is far in excess of what we ever asked for or expected, the risk of a jury coming back and giving you nothing, the risk of a jury giving you something in the middle, the risk of an appeal. And I explain to you all the risks associated with turning down this particular settlement offer. Importantly, I mentioned that if you go to trial, there's no guarantees at all, and it will take you at least another year or two to get a final decision if the verdict is appealed by the defense. Because if you get a verdict far in excess of what we believe the case is worth, I guarantee you the defense will go ahead and appeal that decision, and then that will now drag on for another year or two before we get an answer. And you should know something else. If the defense goes ahead with an appeal and wins part of the appeal, it is possible that the appellate court, the higher court, will now send us back down to try this case all over again, or try damages all over again, in which case we're basically starting from scratch, and now we have to go through the same process to determine whether or not a jury is going to give you a substantial amount of money as compensation for all of the harms and losses and damages that you incurred because of this doctor's carelessness. So now we have this honest discussion. You tell me you need to think about it. You tell me you need to discuss it with your significant other and your family. I say, fine, but just be aware of this particular time limit. So now a few days go by, and I reach out to you and I say, hey, what's your answer? I need to know. Because if you choose not to accept the offer, I have to prepare for trial. I have to start getting ready. If you accept the offer, great. Now we'll go ahead and prepare the closing documents to settle this case. And now you don't call me back. And now, 4th day goes by, a 5th, a 6th, and now I'm getting very concerned. So I pick up the phone and call, and I don't get you. I don't reach you. I get your voicemail. I send you a text. I send you an email. I leave you a voicemail. I say, you've got to let me know. Otherwise, by default, if you don't answer, that offer is going to be withdrawn. And I don't hear anything from you. So now, on day 7, nothing. I don't hear a word. I hear crickets. So now on day 8, I get a call from the defense attorney. He says, Gerry, it's been a week since I spoke to you. Because you did not reach out to me within the week, we are now withdrawing our offer. And I explained to the defense lawyer that yes, we spoke. We had a conversation. I explained the risks of waiting beyond the 7 days. And I'm concerned and I'm worried because I left multiple messages and I did not get any call back. I did not have any ability to communicate with you during that time period. And I'm concerned that something may have happened to you, my client. And now I explain this to the defense attorney. He says, look, I recognize, I understand that something may have happened. You may not have been able to communicate with your client after that, but I gave you my word. This is what the defense insurance company wanted me to do, and I have no choice but to withdraw this offer. Can he do that? The answer is, yes, he can. The defense can put a condition or conditions on the offer, and if it's acceptable, great, we go ahead and settle the case. If it's not acceptable, fine, we don't settle the case, we go to trial. And that's the risk that my client knew about going into this. So what do you think happened? So now, 2 weeks after I had this conversation with my client, she calls me and says, Gerry, I'm considering the offer. I said, it doesn't matter whether you're considering it or not. The offer is off the table. And she said, what are you talking about? I said, I told you very specifically that this offer was valid only for 7 days, for 1 week. And that if you did not respond within that time period, that offer would be withdrawn. And she became very upset. And she made all sorts of excuses about why she didn't get my texts or my emails or my phone calls. And you know what? She got every one of those things. She intentionally chose not to answer them. She intentionally chose not to respond to me within those 7 days. And so what happened? We had no choice but to go to trial. So why do I share this great information with you? I share it with you just to give you a real understanding of what actually goes on in these medical malpractice cases in New York. You know, I realize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen in New York and you're thinking about bringing a lawsuit but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.